All right, good morning and welcome to JLCAR. It's 9 o'clock. We have a quorum and Representative Grassi can sit in for Senator Lang and Representative Hacken Phillips for Senator Innes. And Representative Fellows is on deck. All right, meeting minutes of the previous meeting. Do we have a motion?
So moved.
Second.
Any additions, corrections, or comments? Those in favor?
Aye.
Aye.
Opposed? All right. Hearing none, thank you very much. All right, the consent agenda. Does anyone have something to remove from the consent agenda? All right, seeing none, is there a motion?
I move to adopt as presented.
Okay, moved by Representative Schmidt, second by Representative Lynn. Any discussion? Those in favor?
Aye.
Opposed? All right. Thank you very much. That gets the consent. That gets us to item number 3A, the Department of Education.
So this is 2024-41. This is on the minimum standards for public school approval, education 306.01 through 306.26. It says 25 on the agenda, but it's 26. This is the first half of the 306 rules. There is a second half that has not been filed as a final proposal yet. What you have before you is a conditional approval, and it could be on consent. I have no substantive comments. I have one note to JLCAR about there was a comment on the initial proposal about inadequate fiscal impact. However, after further review, we saw that it was a existing requirement that was already in the rules, and so it made no change to the fiscal impact, so the impact statement was correct. Other than that, I have no comments on this proposal.
All right, thank you. I do have two people who'd like to speak. Christine Downing and David Trimble, who each want 5 minutes. I hope that you will be able to focus your comments specifically on the rule that you object to, and not just saying I don't like the whole thing, because that doesn't help us to decide if this is a legitimate rule or not. Mr. Trimble?
Is that working?
Yes.
Good morning, Madam Chairwoman and committee members. Thank you for having me. My name is David Trumbull. I'm from the town of Ware. I have a couple of concerns about these regulations. First, I'd like to go back to 1981 when RSA 541A was rewritten. The legislature sent a request to the Supreme Court for an opinion of the justices on the constitutional aspects. The court wrote back that administrative agencies can only fill in the details. They can't add to, subtract from, or in any way modify a law. They can't substitute their judgment for the legislature. The reason for that is separation of powers, because the only branch of government that can make the rules is the legislature, not the executive branch. So I'd like to look at two statutes in particular that I think these regulations run afoul of. First is 193EB. When that came about and was updated in 2007, it was a direct result of the Londonderry decision. In the statement of purpose of that piece of legislation, the General Court said that we embrace our duty to live up to the constitutional duty to fund the public schools. And it's through this statute that we're going to define how we do accountability. How do we tell the people of New Hampshire that we're living up to this duty? And they laid out a rather long set of details. The most important part is that in the first sentence of that statute, they said it has to be inputs and outputs based. In other words, we don't get accountability by, is a student making progress? We do it by inputs. Do we have classes and teachers and resources? Just as much. That has to be part of what makes accountability. These regulations diminish the inputs part of the regulations, and I'll get into that when I get to the regs. The other statute I'd ask you to look at is 18924, the standard school statute, which was written in 1919, but still in effect today. It was just amended in the last decade. That requires buildings, classes with furniture, teachers, and instruction. This is how we define inputs in this state. Buildings, classes, teachers with materials and instruction. Those things are removed from these regulations. So let's look first at the current regulations. The current regulations define class size. They use the word class size. They specifically reference teachers who teach and give you mandatory shall numbers of teachers. They also reference specifically each school shall have instructional programs and define instructional time as that which is under the supervision of an educator, which used to be defined as a teacher. The proposed regulations eviscerate these regs. So first of all, let's look at class size. They take out the requirement for class size. They take out the word class. Instead, they have student educator ratios. There's no requirement that there must be this number of educators. There's no penalty if they don't.
Excuse me, sir.
Yes, ma'am.
I'm sorry, I don't think that you are looking at the final version of these rules, because the class sizes are in the rule. They're in the conditional approval. They're in the final proposal and in the conditional approval.
Could you, yes, I noticed that that was changed between the interim and the final and the conditional approval request. So if you could make sure that you're talking about the latest version, because I know that the Board of Education has revised that section due to public comments at previous levels.
I'm referencing, I went on to the DOE website last night under what's final proposal, August 14th, 2024. Is that's the one that we're referencing?
No, there is a conditional approval request, which is dated September 11th. It's in the JLCAR package on the legislative website.
I'm sorry, it's dated September 12th, is it not?
The letter is September 11th. The conditional approval request is September 12th. You're correct.
I'd like to ask a question.
Yes.
If you could you tell us what number in the rules that you're reading?
Okay,
Could you tell us what number you're looking at?
certainly. In the,
Thank you. 36.1.
that's the one that's the one I'm looking at in the current one. The previous one was 306.15 and 306.17, which was called class size and had the word shall, and you had to have educators with class size requirements referenced later. That provision that you had to have, the local school board shall require that each school provides educators with class size requirements. I believe that's still not in the, it was certainly taken out in the August one, unless
It's
it was.
on page 12 of the conditional approval. It's 306.14, paragraph A. The local school board shall establish student educator ratios to promote student learning for each learning opportunity and learning level based upon school safety policies, content, instructional method, the characteristics of learners, and the following. For kindergarten through grade 2, 25 students or fewer per educator. For grades 3 through 5, 30 students or fewer per educator. And for middle school and high school, 30 students or fewer per educator.
That's exactly the same as it was on August 14th.
Excuse me.
So that has not been changed since the August 14th version.
It was added back into the proposal.
I'm looking at the August 14th one, and that's in there. What you just read, word for word, is what's in the August 14th one.
Representative Fellows has a question.
Thank you. I'm Representative Fellows. I worked at the Department of Education for 30 years, and class size is not the same as educator-student ratio. Class size means how many students are sitting in a room when a class is being taught. The ratio is a completely different number. For decades, the Department of Education has been publishing numbers that tell you the average class size in a particular district or school, education, educator ratio, if it's published, it is totally not the same statistic.
And your question is?
I'm wondering why the attorneys think it seems to be synonymous.
Would the department like to answer that?
Could you please step up and introduce yourself?
Julie Shea, Administrative Rules Coordinator for the Department of Education. If you continue to read that further, you'll see that it says that as long as the schools shall strive to have a class size of 20 or fewer. So it does use class size in each section. So it talks about the student educator ratio, and then it goes further to say that the class size is the ideal number. So we did not eliminate that.
Representative Bracken Phillips.
Thank you, Madam Chair. Is it also true, Ms. Shea, that the definition for educator has changed, whereas the existing rule used to just include teachers, administrators, and one other addition, but now under the new definition, there's several more possible paraprofessionals who could be included under the term educator. So in fact, the class size of the ratio could affect how many students to actual teachers are in the room, because if the definition of educator is expanded to include those who do not hold a teaching certificate or license under the state, that there could be, you know, for instance, a teacher and, you know, a special ed, or like a paraprofessional who's designated to 1 or 2 students in the classroom, but because now there are 2 adults in the room, that there could be more students per this new definition of ratio.
Can I address that, please? I was, but going to be my next point, which was under the existing reg, an educator is a teacher or a specialist or a staff or an administrator. 25 to 1, every classroom in the state just about has got one paraprofessional in it. But you have to have one teacher for those 25 students. Under these regulations, if it's educator, you could have 50 students in that classroom, one teacher and one para, who could be assigned as a one-on-one to one student, which means you basically have 49 to 1. That would be acceptable under this set of regulations.
Thank you for your answer.
Senator Whitley.
Yeah, I had another question for the Department of Ed too on that issue, if I may. So she referenced the language about strive to have, but I think that's clear. Wouldn't you agree that strive to have is very different than having a hard cap? Isn't that correct?
I'm going to go reference. I think that this language is almost verbatim.
Could you please step up?
Just got to get the original rules. So looking at this rule, yep. So for the record, Frank Gable, Commissioner of Education, and I may call on Julie to help me understand some of the changes that we've made. So this was the language that we worked very closely with a number of the various advocacy groups to try and develop something that would meet everybody's expectations. The original rule said, was focused on kindergarten grades 2 through 25 students or fewer per educator, provided that the school shall strive to achieve a class size of 20 students. So that language is the exact same language that existed already in the rule, and we did not change that at all.
So that, excuse me, Commissioner, so you're confirming that that is the current class size rule that is effective right now today?
That's correct. And it says right in there, it says, I'm reading from the current rule that's in effect, not the proposed rule. Grades 2, 25 students or fewer per educator, provide that each school shall strive to achieve a class size of 20 students or fewer per character. So we've kept the same language that already exists in the same statute.
And the current rule does in fact say educator.
Correct.
Follow-up, please.
Yes.
But it's it's the case that what was changed was the language from cap to ratio. Isn't that correct?
So, but it says ratio in the title because what we've done is in the introductory. So the only thing that's changed in this rule is that in the introduction, we introduce a concept of how you would develop student educator ratios. So it initially just talked only about the class size language. And so what we've added to it is that local school boards shall establish student educator ratios that promote student learning for each learning opportunity and learning level based upon, and these are the inputs into determining the ratios that you would have of safety policies, content, instructional method, and characteristics of learners. And then we kept the exact same language relative to class size and did not modify that at all. And the objective here that we were after is really there's the balance on the other side as well, because quite frankly, if you have, excuse me, if you have a class of second graders that are struggling readers, 20 or 25 may be too many. And so what we've tried to introduce is this concept, like you really need to look at, considering safety policies, what is the nature of the kids that you're working with? Are you working with a bunch of autistic children or something that need more support? The content that's being taught, the instructional method, and the characteristics of the learning. So if you're in a second grade class, and you have 20 struggling readers, that's too many. And so what we've tried to say is, here's the minimum class sizes. This is what you got to basically strive for, the maximum class sizes. But before you just default to 20 struggling readers in a class, consider safety, content, instructional method, and characteristics of the learners. So we've not changed the class size requirement at all. What we've added is guidance to the schools in terms of trying to understand who's in front of you before you just default to a certain, maximum class size number, which we believe is better pedagogy.
Yeah, so just to confirm, you did remove the cap language, so now there is no cap.
No, that's not the case. There is no cap that was removed. The existing language says kindergarten, grade 2, 25 students or fewer per educator, provided that each school shall strive to achieve the class size of 20 students or fewer per educator. The current proposal says the exact same language. There was not changed at all. No words were changed at all.
Okay, thank you. Representative Fellows?
So I just want to explain
Just don't lose my page.
that what you see under A is not what it says in the current language. The current language under the line A says class size for instructional purposes in each school shall be.
Thank you.
And then under that is 1, 2, and 3, which is exactly what you are looking at.
Thank you, Representative Fellows.
Then B, what you see is B in here did not exist in the does not exist in the current. I'm calling them current, rules.
They're the currently effective rules, yes.
So I would just want to clarify. So B does exist in the current rule. The current rule says that, class size requirement may be exceeded for study halls, band, chorus, other types of large group instruction, including but not limited to lectures, combined group instruction, and showing of educational television and films. And the current one still says student education ratios may be exceeded for study halls, bands, chorus. So we basically kept the same language in there.
Thank you. Representative Leon has a question.
Yes, thank you, Madam Chair, and thank you, Commissioner. As I'm reading this, the additional language that you added appears to accommodate for conditions like my mother dealt with in her third grade classroom, where she had some students who came in with no concept of a written language, and many others that were performing at kindergarten reading level, even though they were in third grade. Does this provide for a justification for smaller class sizes when it's necessary because it says that it needs to deal with the student learning opportunity and learning level?
So of course, that's the point, is that basically we want our educators, when they're setting the class size, to not start with just some number and say like, okay, we can have 25 students in a class. We're going to have 25 students in a class. You may need to have fewer students. They were previously allowed to have fewer students. Now we've listed some criteria that should be considered when deciding whether you want to have a different ratio.
Thank you.
But you still can't exceed it.
Thank you. Representative Hacken-Phillips?
Thank you, Madam Chair. I'm just wondering, for purposes of the JLCAR committee internal discussions. If someone could please point to the legislation that's been passed since the last rule adoption that is directing us to change the definitions of class size, educator, and move to the class ratio model.
So just to be clear, okay, this is for you.
That was a
Yeah.
question too.
The statute, if I understand correctly, has definitions for educator.
And the definition for educator in the statute is the same one that's in this rule. Is that correct?
I believe so.
So
Could
which
you repeat
statute are
that?
you referring to? Because I'm not familiar with a request to change the definition of educator.
So we've not changed
So-
any definitions. The only changes that we've made in here is to try and make sure that we're aligning any statutory definition, and this is input that we got from the Legislative Oversight Committee as well. Any definition that we've used in here, if there is a statutory definition, we've adopted it into this rule.
So that the previous rules had a different definition than the statute. Is that correct? Is that your understanding? Director Morrow?
Not answering that question, but to answer Representative Hacken Phillips, if a statutory definition exists, then that has to be used in the rules.
Madam
What-
Chair?
I don't think
Yes.
Madam Chair, I would like to move a preliminary objection on this issue. I think there's a whole host of reasons why these rules are contrary to public interest, which is a clear basis in the statute for an objection. I think for 3 years at least, parents, students, educators have raised these exact same concerns that we are addressing today, and the confusion abounds. And so, you know, I feel like in addition to contrary to the public interest, because of a whole host of problems that it could cause for property poor districts, the input that was provided to the Board of Education and the Department of Education really was not incorporated. You know, there are other problems with these rules in addition to the class size. I'm just speaking to my motion. So, you know, there's volumes of opposition to this that wasn't considered. You know, this is going to result, as the evidence was submitted, this is going to result in potentially schools and property poor districts could see a dramatic increase in class sizes due to sort of pressure on school boards. You know, I think we really need to consider the public interest here, particularly for those students who, you know, we know in our schools we have increasingly complicated academic and mental health needs. If you're going to potentially increase class sizes, that's going to, you know, lead to a situation where individual needs are not met. That's one reason why this rule does not serve the public interest, which is a clear basis for an objection. The other, which we haven't talked about, the basis is we are shifting from courses to learning opportunities. We can have a further conversation.
Excuse me,
about that, but
your-
that's the basis for the objection.
Your objection is on this specific section. Is that correct?
My objection is based on the statutory objection that is contrary to public interest, and I was going through why. So one is the class size section, the other is the shifting from courses to learning opportunities, which I can.
So if I might just
To
clarify.
To
Thank you.
clarify the question that was asked, there is no statutory definition of educator. We just did a search. We cannot find one. That means that the department has the ability to set the definition of educator. They did change it from the previous rule. It is a different definition, but it is not a statutory definition. If it was a statutory definition, they would have to use that definition, but it is not defined in the statute. So just to be clear on that.
Yes, Director Morrow.
I think a motion at this point would be premature. The reason being, committee rules require an opportunity for public testimony and for the agency to testify.
So if can I just
Fine, we will hold off on dealing with this motion, which hasn't had a second yet. And so we will let the agency respond to the comment by Senator Whitley.
Okay, and I'll also just clarify here. So the change to the definition of educator was in the old rule, it made reference to RSA 18939, which only included superintendent. So the old rule had an incorrect citation to the statute. So we've not made a substantive change. We've made a technical correction to it if you look at the old definition versus the new definition. And Senator Whitley, I just think it's an incorrect characterization that says that this would allow for unlimited class size. In fact, this rule was, from the initial proposal, was modified specifically based upon that public input to provide class size limitations, as we've just explained, and those are in this rule. So I think it's an incorrect characterization to say that there are no class size limitations, because they're very clearly enumerated in the rule set.
Thank you. Okay.
Madam Chairwoman, can I comment, please? I'd like to respond to two things that the commissioner said. He said that they didn't make any changes. There's two important changes that were made. One is this issue of educator. It may be, in their point of view, a technical correction, but it changes the impact of how the regulations play out in the real world. Because right now, you need one teacher for every 25 students. Under the way these regulations are currently worded, you could have one teacher and one para for 50 students. It's more than a technical correction. The second thing is that if you look back 2 sections before the numbers section, where you have the 1 to 25, the previous set of rules, which had been in effect until just a moment ago, says to carry out the educational program established by these rules, the local school board shall require that each school provides educators in accordance with class size requirements in 306-17. That has been stricken from the one that was written in August, and I don't think it's in the brief chance I had to look at the one from September. That precedes, in other words, the numbers section is the numbers section, but the section that came right before it said, you shall do what's in the numbers section. So the shall do part was stripped, and the numbers part was changed. The effect of those two changes is to mean that you could have 50 children in a classroom with one teacher and one para under the rules that are being proposed. That would not be acceptable in the status quo.
Thank you.
I have one more point that I didn't get to. We kind of got a bunch of other people speaking. Can I please make my
Please
second?
make your last point, please.
Okay. So the first was class size. The second is the issue of instructional program. And again, I go back to RSA 189 that says there has to be instruction. That's a statute. It was required. 193E set up how do we measure accountability? It's instruction based. There's a long whole section in there. The current regulations, I'm using current for meaning the ones that have been in effect for the last 10 years. In section 26, which is kindergarten through 8th grade, and then the next section, which is high school, reads simply, the local school board shall require that in each school there is an instructional program that includes, and then methods and strategies for teaching. You have to have an instructional program in the present system, and that must include teaching. You have to have teachers who teach. RSA 189 says they must be teachers who teach. These regulations remove that. They took out the word instructional program.
Would you please point to the part in the rule under consideration
Oh, I will be happy
where you
to.
made
Yes.
that change?
Okay. So
So
again,
we can follow it.
okay, great. I'm sorry. I'm using the August 14th one. Let's see if,
Probably the same section number.
right. Okay. If you go to 306.22, for instance, high
Point
school
22.
curriculum
Thank you.
credits and curricular programs. It says, the required locally improved curriculum content shall comply with the following. The program of studies shall include those learning opportunities in which students demonstrate achievement of competencies. The first point I made has been lost here. It was the statute, 193E says you have to have inputs and outputs equals accountability, both. This rule says that all the curriculum has to have is a program of studies that includes learning opportunities in which students demonstrate achievements of competencies. There doesn't have to be an instructional program anymore. There doesn't have to be a class with teachers with instructional programs. And the second half of this that you're going to get next month, which should have been included with this for a fair examination of it, required that for each subject that's listed in 193E at each of the 3 levels, elementary, middle, and high school, there's like 8 things you have to do for math, 8 things you have to do for social studies. And it had the word shall for each one of them. That was stripped in the regs to make it may. The statute says you have to have instructional programs that are taught by teachers. The current regs said instructional programs taught by teachers. The future regulations got rid of the the instructional program language and just calls them learning opportunities. Well, the only way we know if we have accountability is if people actually achieve the competencies. But there's no penalty. What if only 20% of the children achieve the competency? There's no penalty there. The only way you know if you have accountability is inputs. And I would lastly reference you to the Conval case. The judge in that case,
Please, let's not confuse us with the
oh,
legal.
all I'm saying is that he looked at that and he said, how do we know how much we have to spend? He said, I'm going to use the inputs-based system because that's what's required by the Constitution. That's what's required by existing statute. The regulations should match the statute. It should be inputs-based.
Thank you.
You're welcome.
There were other questions? Representative Fellows?
Yes, I'd like to talk about use of the word educator. So from the current statutes, which defines educators to include administrators, specialists, and teachers, it is clearly changed in the new statute. But in both the existing statutes and the new ones,
Excuse me, are you talking about statutes or rules?
I'm rules, I'm
Thank you.
sorry. So,
It's important.
okay, yeah. So in the existing rules that we're have and the ones that we're looking at to be changed, the definitions are different, but in both cases, throughout the entire rule, when you look at it, where the word educator is used, which is in many places, it's clear that the individual rule does not apply to all of the characters that are identified in either of the definitions. So it doesn't make any sense because I was a business administrator for a school district. I had no business being in a classroom. So, you just have to take that for the way it is. And
Thank you.
it'd be nice if we could fix that, but that would be a big project to fix that.
The department has a comment?
Yeah.
If you're a business administrator, you're not qualified. You would not, by these rules, you would not be eligible to be an educator in the classroom. So
Doesn't it say though, you have to be certified to be a business administrator?
well, first of all, we don't have a business administrator certification, and we've enumerated in educator the various rules.
Did you get rid of it? Because I used to have a
It's been gone for some time.
certificate.
Yeah, this board approved that rule
Well, okay.
probably about 18 months ago. That's been gone for some time now. Hi, Elizabeth Brown, to identify myself. I'm counsel for the department. I've been involved with these rules with Julie Shea throughout, and I just wanted to come and make sure that I was cleared up the question here about the instructional program being removed. Instructional program is a term that is defined by statute. It wasn't defined by prior rules. If you look at 306.12, the terminology that we've changed to rather than instructional program is educational program. That more mirrors the statutes, also is in line with the rules. We've also defined program, importantly, in these rules, because really that's what we were trying to do. When we were going through the old rules, there was a lot of incongruence between the rules themselves and and statutes and rules. And so we were trying to go back and have fidelity to the educational statutes in these rules. And that was really my focus. I'm an old trust and estates lawyer, so each word has meaning kind of training, and that's the kind of fidelity that I laid these when we were doing these administrative rules to the statute, and wanted to make sure that we were very, very careful in using the same word in the same way in the rules that we were using and that the legislature had used in the statute, because that fidelity is so important, and it had kind of gotten lost in the mix, and we had created kind of a different nomenclature in the rules. And I think that led to a lot of confusion. So if you go back to 306.02, if you look at program is defined now. It means a grouping of interrelated activities, opportunity, and resources designed to implement a particular goal. Also, because these are intended to be, competency-based learning, we've defined, learning levels, but we've also defined competencies, and we've gone back to define those specifically, not in some other fashion, but exactly how the legislature has done so. So, I mean, if that's the really important thing here is we may have taken out instructional program. I'll give the gentleman that. But if you go back and you look at the fact that we've adopted educational program, that's the language that's now used. We've defined program. We've made sure that that follows with the statutory definitions. It's very, very much trying to create a very close correlation to the work of the legislature and make sure that these rules implement exactly what the legislature has given the state board the authority to do so. Speaking to the back half, because I think there was an initial draft that was brought before the board as an initial proposal that had included the word may instead of the word shall. You would note if you went and pulled the board packet that was before the state board on Monday. That is not the proposal that went before the state board. That is not the proposal that the state board approved on Monday. The shall be there. It is very consistent with the statutory authority of the state board and the manual and the process and the procedures that JLCAR has demanded of rulemaking bodies. So if you, rather than pontificating or trying to talk in theory about what was in front of the state board back in February, I think that before we have that conversation, you need to go look very specifically at the proposal that was approved by the state board on Monday. It was very different. And we had actually had a conversation with OLS's attorneys and tried to make sure that we were following process procedure and we were keeping fidelity both to the administrative rules process and existing law. So I think, you know, we've got to be very careful when we're talking about different proposals that everybody's on the same page and we're talking about the same proposals. And right now we're kind of passing as two ships in the night in this conversation.
Thank you. So can I summarize your comments by saying that the old rules were not necessarily properly aligned with the statutes, which God knows have been amended many, many times. And the part of the confusion is that some of the language that's been carried forward in the old rules has been changed because it is no longer supported by the statute. Is that correct?
Yeah, there was that's a pretty good summary. And we really tried to go back very cautiously and carefully and go back to see if there were definitions to things that were in the rules. And we found by surprise that the legislature had done our job for us. And so our job, if you defined a term, is to use the term that the legislature has used. And so we have gone back between the time that the initial proposal went before the state board and this proposal came before your body. We have done a very careful process of that, word for word evaluation of this and discussion with the state board on why we have done that, because we want to keep fidelity to the education laws as they currently exist.
Thank you.
Madam Chair.
Yes,
May I make one response to that?
yes.
Thank you. I understand fidelity, and I think that's a good goal. The definition of program says a grouping of interrelated activities, opportunities, and resources. Nothing in there says teachers who teach students. If you look at the existing regs, it's an instructional program, is methods and strategies for teaching students. If you go back to RSA 189-24, it requires that in these schools, it is taught by teachers. That's statutorily required in existing law. So I think there's some fidelity that got lost. I understand the idea for alternative education and that there are other options that could be applied. That's good. But what these regs do is say we're going to take that and make that the minimum requirement for everybody, which is different than what we have in the present system. We should take what we have now, keep it, and maybe add on some of these alternative opportunities and activities, but not replace having teachers teach students. That's the law we have right now. Statute, law, I use that word specifically.
Thank you.
You're welcome.
Representative Leon?
Thank you, Madam Chair. Sir, if you look to the rules that are in the conditional approval packet, I believe that you will find that all under educational program in the Ed 306-12. I recognize how challenging it is to go through all of this, and I'm benefiting from the find function. But I see that. I see where somebody needs to be licensed if you can only do so much outside of where you're credentialed. And I believe that that is all in these rules as they're moving forward.
If I may, if you look at 189-24, which is standard school, It is the only definition of school that appears anywhere in the education statutes. It is an awkward rule to try, it is an awkward statute to try to employ. It doesn't mention teachers anywhere, but it is the only definition of school that the department has to work with, something the legislature might want to consider. But there's nothing there about teachers. It simply it says a standard school shall provide instruction in all subjects prescribed by statute or by the State Board of Education for the grade level of pupils in attendance. That doesn't even tell us by who the instruction is supposed to be provided by. So that definition of standard school doesn't get us anywhere.
Thank you.
Madam Chair, on one reading right off of 18924, right after that part, it goes taught by teachers. Are we not reading the same statute?
That's not.
It says current through the 2024 legislative session. Yeah, right there, taught by teachers.
Okay, go ahead. All right.
Just to clarify our process also, the department submitted an initial proposal, and that initial proposal had comments almost on every page. That initial proposal and the comments and the public comments that came in for that initial proposal went back to the Department of Education, and they created a final proposal draft. That final proposal was the purpose of it was to satisfy our comments as the committee attorneys and as the public made comments on the initial proposal. So the two texts are not the same. And that I think is very important here, because if you're looking at the first one, it is not the same as what we're talking about now. They filed the final proposal. It satisfies most of our comments and the comments that we had heard from the public. And then they did a conditional approval to clean up some other things. And so that's what we're reviewing now. So I just want to make sure that everybody knows that it's the conditional approval that we are reviewing. It's from September 12th. And again, I have no comments on this proposal.
Okay.
May I just bring your attention to 306.12, because I think that may better address the issue. If you go through 306.12, talks about provision of staff and staff qualifications, and it goes through the particular requirements of what a school has to do in order to carry out the educational program. And so it goes through and it tells what the services have to be provided, how they have to be provided by licensed educator, how a school district has to hire and train their educators, that they're licensed under the 500 rules, facilitate learning in their credentialed content area. So I think if you look at that at 306.12, that very specifically addresses the concerns that have been brought forward today.
Okay.
Madam Chair, is there
Yes.
further input that we need to receive?
Yes. Thank you, Mr. Trumbull.
Welcome. Thank you very much.
Representative Fellows?
Yes, I was just thinking that in 306.12, it uses the word educational program. In the definitions, it uses the word program, which it says particular goals. It doesn't say anything about a curriculum or academic standards. I don't even understand why there would be a definition of just the word program even in here. It makes no sense.
Thank you. Christine Downing?
No, you turned it off.
Now it's on? Okay, sorry. Christine Downing, Goshen, New Hampshire, 30-plus year educator, all the way from elementary, middle, high school teacher to principal to active curriculum director right now. I do want to make a point of clarification, and I am going to draw to two references. And I hate to do this, but I am going to belabor that definition of educator for a second. But before I do that, I ran, so this committee is fully aware. As a volunteer, I was not part of the National Center for Competency-Based Learning, but I ran 10 educator review sessions in the month of March of 2024 throughout the state. I got feedback from over 300 educators, and I am going to go on public record today to say that the language around the educator student ratios and that class size language was not recommended by the educators. In fact, they suggested edits to the existing rules that would clear it up. So that I am going to go on public record, and I have the data, if this committee would like that data to look through,
We
to back
would-
up
we
that
would-
educators did not support that.
We would appreciate it. I don't,
Yeah.
I'm not concerned that the data on how many educators supported it. I would like to have the specific edits you referenced sent to the committee.
Yep, I can do what the edits were that they suggested, the educators themselves suggested.
Thank
I
you.
absolutely can do that for you. Absolutely, Madam Chair. I want to just go back to the educator conversation about what the current rules say. The current rules define educator as means any professional employee of any school district whose position requires certification by the state board pursuant to RSA 18939. The term includes administrators, specialists, and teachers. That's what exists currently in the rule. There was a comment made that RSA 18939 was irrelevant because it spoke to superintendents. But I want you to hear what 8939 says, because I'm going to contend today the removal of that significantly changes the definition of educator. 18939 currently, effective as of 2024, says superintendents shall nominate and school boards elect all teachers employed in the schools in their school administrative unit, providing such teachers hold a valid educational credential issued by the State Board of Education. The removal out of that of the definition of educator and the addition of particularly, and believe me, I value our paraeducators, but the new definition lists all these people and basically just says those who are credentialed by the Department of Ed. What you need to keep in mind is that a Para 1 certification only requires the completion of a high school diploma. By the definition in these new rules, with these, whether you want to argue their educator ratios or class sizes, here's the situation it creates. And this is a real world situation I'm dealing currently as a curriculum director. Currently, I am a small rural school district where I have one teacher per grade level. We had an influx of enrollment in our second grade. It bumped our second grade to 28 students. Okay, so it bumped them to 28 students. If I took today's rules, I would need to go to my board and say, we're going to have to figure out another teacher. We're above it. If I go to the rules that get passed, they're going to be able to say, we don't need a certified teacher, which is going to cost us more. We're going to put a para in there. Now, here's what I'm going to tell you, because under the new rules, that para would be defined as an educator, and we would now be at a ratio of 1 to 14. So we'd be under what's stipulated as a proposed rule. That being said, the responsibilities of those 28 students when it comes to instructional programming, lesson planning, assessment, meeting with parents falls under that teacher. This is and to use Senator Whitley's language, there are many contrary points in these rules to the RSAs themselves. Exactly what David Trumbull spoke about the RSA, and I totally respect the State Board of Ed and the Department of Ed for the fidelity conversation of holding fidelity to the RSA. But let's do our due diligence in these RSAs. The change in that term of educator is what's creating inequities in our school districts. My board, if these rules were adopted and passed, my board could say, we're just going to add an educator. Another district that's 20 miles away from me, who has decided to put a policy on their local level, which they could do. I'm not going to argue anybody that a school district can set their own requirements for class sizes and ratios, could decide to do a policy where they limit and make that decision because they have that kind of financial ability to do that and hire other people. Whereas one of my rural districts that doesn't have that financial ability won't set that policy and they defer back to these minimum standards approval. We have to think of the lens of equities to our schools across the state for these rules. Now, I am going to give up another whole section. Thank you for the time. But there are concerns in section ED 306.22. And just give me a second on my laptop because I am looking at the packet, that JLCAR, because I pulled it down this morning. And here's where I want to bring some concerns to light. I hear the conversation about fidelity and fidelity to the RSA, particularly RSA 193E 2A, which is the definition of an adequate education. And here's where I'm going to start to pull some things out. In a tech advisory that was written in September of 2022 by the Department of Education related to personal finance literacy, they used the interpretation that in RSA 193E2A, paragraph 1, when it lists out the learning areas that should be included as the definition of adequate education, they unilaterally interpreted that list to mean they had to be standalone classes. Here's what I mean. The original law that governed the implementation of personal finance literacy clearly stated that personal finance literacy could be integrated and applied into other areas. Yet, in the proposal in 306.22 here, where they list the graduation credits out that they're proposing, they're going to hold them steady for now, but for the following year, they're proposing a half credit of personal finance literacy. Where in the RSA does it give them the authority to usurp the law that was written that implemented personal finance literacy to be integrated to now be a standalone credit, which most will interpret as a standalone course? It doesn't. And in fact, when that law first came out, many high schools incorporated, as the law had stated, personal finance competencies in their economic classes, which were a half credit. By adding that half credit to personal finance literacy, they took a half credit away from our New Hampshire students in their electives. They eliminated student agency and choice and voice in what kids can do to design their learning pathways in high schools. That's the very essence of competency-based education. Another example I will give you real quick, again in 306.22, going back to the fidelity of RSA 193E 2A, is that in paragraph 1, section B, it clearly also says that logic and rhetoric shall be integrated and applied. Yet again, they pulled out logic and rhetoric to make it its own half credit. Again, taking electives from our students. We are minimizing, if these rules move forward, we are minimizing the high school experience for our students to be a compliance checklist. We are not making our public schools a place where kids can explore and find out who they want to be. I can continue, but I'm not going to eat your time up. I've got more examples like this. I will be happy to submit the written details of more exemptions like this that exist in the effort to make things have fidelity to the RSAs. It's been a pick and choose when it comes to the fidelity. One other quick thing I will point out is that in that same section, I believe it might be under section 3 within 306.22, there is a list of areas that high schools are supposed to have. In that list, it contains business education, yet it removes family and consumer science. The board discussed at its meeting how they were removing it because family and consumer science was not listed in RSA 193E2A to define an adequate education. Okay, I recognize that. You're trying to be faithful to that RSA. Then my question would be, then why is business ed still on the list? Fidelity is fidelity. You hold it as a line. You don't choose when you want to have fidelity and when you don't. Thank you.
Thank you. Thank you very much.
Madam Chair,
Yes.
I'm just wondering if we could ask Ms. Downing to send us those examples in addition to the comments that were made on educator, but also the examples that you have in these kinds of situations, in addition to besides business education, and that would be very helpful. Thank you.
I would
It would
absolutely-
be helpful to me if it's okay with you.
That's
Absolutely. I just need to know, is the current list on the website, like current with all the active members? I want to make sure I get everybody.
Yes.
So,
Yes.
yeah, okay.
Yes.
Yeah, I will use the website and absolutely send you materials.
Thank you.
You like the department to comment?
Sure,
Commissioner?
I'll try and clarify some things. And we so appreciate the work that Ms. Downing did in terms of gathering public input from many of our educators. And we meticulously went through that input and tried to incorporate any comments or changes that they had into this rule set. And we believe with fidelity, we have included those. I've just I'm happy to answer any questions, but I will also just address a couple of the items that she brought up. And again, we still seem to be going around about this concept of educator. Educator as a term is used throughout this rule proposal, but I will again point you to ED 306.12, provision of staff and staff qualifications, where we talk about to carry out the educational programs which are required in these rules. The local school board shall require that each school provides under 2, it says professional staff member licensed by the department in accordance with 500 and 600. Under B, it says, and that an educator with sufficient content knowledge as determined by the superintendent may be assigned to teach in a content area in which they are not licensed only as a minor assignment. So it is not that they can just be randomly assigned to educate. That would be a violation of the laws if you put a paraeducator who didn't have content knowledge and responsible for running an educational program. The second thing that I will point out is relative to 306.22. There was comments relative to the credits, and I will say that the board spent quite a lot of time discussing the credit table and trying to figure out what it is that we want to make sure that has fidelity to the law, but also helps meet the needs of the students. In the previous rule set, there were 20 credits required to graduate from high school. That's the minimum number of credits that are required to graduate from high school. Most schools have more than 20 credits as the number of credits that they acquire. In that initial list, 6 credits were included as electives for the students. The board's conversation around this, and then in the proposal, they're saying that they should have 4 elective credits, not 6 elective credits. Part of the conversation that the board had around that is they said, if we are, we've got compulsory education laws, so these students are required to be in school. During the time that they're in school, we want to make sure that they're getting the information that we want, and we want to make sure that we're not communicating that an entire year of high school, which would be 5 credits, is kind of voluntary, because then if you think about it, most kids would basically be able to complete all of their academic requirements in 3 years of high school. And then they can spend their entire senior year just taking elective credits. So we've continued to leave 4 elective credits in there, but they have, required some additional changes to that, including, in the mathematics area, they added a half a credit in statistics and analysis. And then they split out some of the other credits relative to the bill that was passed, SB 216 by the Senate, relative to requiring certain history, government, and constitutional classes that they put in there, as well as it is, as Christine pointed out, the board believed that the personal financial literacy was, because it's enumerated in that list, was something that that this body wanted the students to have a dedicated personal financial literacy class. And so that is how that was understood by the state board when they were, discussing the table of credits that would take place here. I don't disagree with Ms. Downing that Family and consumer science was not on the list. So if I go back in that particular rule, where we talk about the classes that are required to be offered, right? So not credit requirements for graduation, but credits that are required to be offered. The board did remove family and consumer science because it was not enumerated in that list. The board had a conversation and believed that that was incorporated into content areas such as social studies, personal financial literacy, and economics, and it was encapsulated in there. As well, the JLCAR comments that we received pointed out the fact that these were not on that list, but business education was not one of the JLCAR comments that we received, so we left that on the list in terms of credits that schools are required to offer. I don't know if that helps.
So if I understand correctly, the legislature has added specific requirements in the last few years that weren't in the previous rules that are included in these rules.
That's correct.
The number of open electives has been decreased deliberately and the specific items that were pointed out as needing to be addressed, for example, personal finance, are specifically called out.
That's correct. So in this rule proposal, the board believed that the legislature's intention was that students would have a half a credit in personal financial literacy.
Okay. I'm sure that that's the minimum, but I would hope that more of them would do more than that. Business education doesn't appear to be on that list that I can see, but it is a requirement that the schools offer it.
Correct. It's not a graduation requirement, but it's required that the schools offer business education.
And what is included in business education that's not economics?
So that's enumerated in the back half. And so it includes a variety of subjects that are competencies developed through the CTE programming.
Thank you. Does anyone else? Representative Senator Chandler.
Thank you very much. My question may be more for JLCAR, the attorneys, than the department, but I appreciate your input as well. Change is difficult for all of us, and I do think it's important that we have these robust discussions because we're going to make a change that's going to be in place for quite a while. We want to make sure we're doing it right. And Commissioner, you just mentioned something that is really of concern to me, and that is the back half. So the question raised by our chair is a good question, and we're going to get the answer. It's potentially that we won't get the answer until after this approval. My question is, should we be doing all of this at once? Would it make more sense? And is that practical? So as I say, that may be a question for many.
Would that other section be ready for our October meeting?
I don't believe it would be ready until the November meeting.
The deadline for this is October 18th. JLCAR would need a waiver to postpone it until the department is ready.
I have a question, Madam Chair.
Yes. Representative Rivera.
When would these, let's just say, when is the effective date? Because your rules have not expired, correct?
No, the rules have not expired. They were filed before the expiration date, which means they continue in effect until the process is over.
Okay, so there's no pending rush for these things.
And the department will determine what the effective date is, considering.
Correct. And so we've included some effective dates. So for example, on the minimum, the graduation requirements, there's 2 dates. We gave schools 2 years in order to be able to implement that, any changes associated with that, I believe. So.
Okay, so that none of them affect the current school year. Is that correct? Other than making sure that
So for the change, so if you look at the draft, there are 2 tables that have graduation requirements because we wanted to give students the opportunity who have already gone into high school not to have the graduation requirements changed or altered while they were there. And so the more we delay these, then we run some risk that students would have the rules changed, or we would need to delay the changes even further, which might not necessarily be consistent with the legislative intent because they've changed some of the requirements under 193E2A in the recent years, and so we're just delaying the implementation of those changes.
right, but for the purposes of the students, I don't know how many of them are having quarter credit courses, but most So for someone who is a senior this year, are you changing the requirements at all?
No, anybody who's in the system gets to stay with the current system until they complete. Right,
Fine,
so
then I
nobody-
think although it may be a nuisance for planning purposes, I agree with the senator that we should look at the entire package at once because they appear to be interrelated. If Senator Whitley, if you'll postpone your motion,
I'll withdraw my motion.
all right, then I'll move that we request a waiver and defer consideration of this rule until we have the other half, which
I'll second
is
that.
estimated
Second.
to be the November meeting. Okay. All right. Any comments, discussion?
I think that makes sense.
Okay,
I do have one question.
yes.
And we may not be able to answer that, but part of the responsibility of the Legislative Oversight Committee in Education is to review the curriculum rules in particular. So I just want to make
That is
sure
not
how
correct.
that.
The Oversight Committee is charged with reviewing the academic standards. These are not the academic standards.
That's correct. I
Yes.
understand that. I'm talking about the second half. I just want to make sure that when we get there, everybody's on the same page and everybody's on the same bus. Okay, that's my question and that's my statement.
That makes sense. Any other comments? Those in favor?
Aye.
Opposed? All right, and thank you all for your testimony.
Yes.
Okay, moving on to agriculture.
Okay, this is Animal Population Control 2024-51. This is an incomplete filing. There is no summary of public comments. I have requested it several times and have not received it, so there is no public comment summary on this proposal. There are some substantive comments, legislative intent for requiring a social security number, which needs a specific statutory authority for, and the department does not appear to have that. And then there's also some clarity issues. For example, in agriculture 2802.01, they're using multiple conjunctions, which makes the paragraph, you can interpret it in several different ways because they're using both the and the or conjunction. There's also another area where they talk about checks and award letters, but those are not defined or described. And so there's some serious clarity issues with the rules.
Okay. Thank you. Does the department have a comment? Please turn your microphone on. Thank
There
you.
we go.
There you go.
Sorry about that. Patricia Benner, I'm the legislative coordinator, primarily hearings officer for the department, and working part-time. So there's a lot on the agriculture plate. However, so I do apologize for lack of completeness. I believe we included in our cover letter, I believe it was explanatory notes rather than a public comment summary was the title. There were no public comments, so that's
All right. Well, that explains why there's no summary.
Just to be clear, even if there are no comments, you have to submit a summary to tell us that there are no comments.
I
So
believe it
I
was
understand
in there.
you-
It just wasn't
yes.
titled correctly. And then I do agree that there are some edits to be made, editorial, but in regards to 2801.03, the proposed would be L, regarding the social security number. So this is really a requirement for the vendor ID. It's pursuant to whatever process DAS has set up. So it's how they get paid. So I think that the authority is within the rule. It's within the statute to allow DAS to establish the payment.
No, any rule needs specific statutory authority to collect a social security number. You can't be derivative. Unless you say here is the vendor identification number means the number assigned by DA as per their rule, which may be the case, and let them collect the data.
Okay. That makes sense. So that is something we can work with the office with specific language on that.
Madam Chair,
Yes, Representative Zerota?
may I ask a question? Yes, thank you. So you say that there was no public comment, but did you have a public hearing? And if so, what was the date of that hearing?
The public hearing was on let me get the exact for you.
April 26th.
April 26th, yep. Yes.
And where was that hearing held?
It was at the Department of Agriculture.
Okay.
There were no attendees and no public comment.
And I trust that every veterinarian in the state was sent a notice.
I don't have personal knowledge of that. Dr. Crawford actually started the process of this rule, and he was the one that attended the public hearing. So I was not involved until recently. So
Okay, because I
can't address the committee with
because
that.
just glancing at the rule, it appears to affect veterinarians specifically, and I would hope they would be noticed. Okay. All right, any other comments? Questions? In that case, I would move we have a preliminary objection based on staff comments,
I'll second.
because besides the editorial issues, you really need to look at the social security number issue and figure out who is authorized to ask for that, if anyone is.
Yes.
Any,
And if I could also ask the department to get back to us on whether or not veterinarians were notified of the public hearing, as opposed to just something, who was notified?
who was notified?
Who was notified besides just putting something in the newspaper?
Besides the registrar.
Correct.
That's not something that I would imagine most people in the state read religiously.
I
So
have
yes,
high
we'd like to
hopes
know
that
if
that was
anyone,
done, and I'll
we
get
will
to
ask
that.
Dr. Crawford who was specifically notified. All right. Any further discussion, comments, questions? All right, seeing none, those in favor?
Aye.
Opposed? All right, thank you very much, and good luck. All right, DES.
So this is proposal 2024-53, the collection, storage, and transfer facility requirements. The only comment I had on this proposal was a note to the committee letting them know that the FIS indicated that there would be a potential increase in cost to the political subdivisions. So we did take a further look into that. The rules, the potential cost would be adding a permit by notification for collection centers for non-select recyclable materials. And I had to get clarification from the department because I didn't quite understand what that meant. And essentially, a non-select recyclable material is something that is not comprised of paper, cardboard, glass, plastic, your typical recyclable materials. So, for example, it would be vegetable oil or tires. So it seems like a completely voluntary program or service that towns would provide their residents. And based on an analysis of the case City of Concord versus State, I did not see that there was a violation of Article 28A of the Constitution. So I just wanted to make the committee aware of that. But besides that, I had no other comments.
Okay. And my understanding is that a permit by notification is much less of a problem than a normal permit.
Yes, I did reach out to the department about that as well, and they explained that there was no fee to apply for that permit, and it is a much easier process than their standard permit process.
Okay. Is the department here? You have any comments or information for the committee? No? Okay. Does someone have a motion in that
Move
case?
to approve. Second.
Okay, moved by Representative Schmidt, second by Representative Lynn. Those in favor?
Aye.
Opposed? All right, thank you very much. That's that one. Additional requirements.
The next one is 2024-56. It is additional solid waste facility requirements. And the issue with this rule is the certifications on the forms are not spelled out in the rule text, so they don't match. And that is a legislative intent issue. And it is throughout the rule in several places for the different forms. A conditional approval would have fixed this, but.
Okay. The agency could say whether they're going to do that.
Good morning. My name is Emily Jones. I'm the rules coordinator for the Solid Waste Management Bureau of the department, and also the compliance assurance section supervisor.
Jamie Colby, I'm supervisor of the engineering and permitting section in the Solid Waste Management Bureau. We collectively have worked quite a bit on these rules, so hopefully if you have questions, we can address them collectively.
Well, the issue is that the certifications on the forms don't match the certifications in the rule text. And that can only be fixed with either a preliminary objection or a postponement and a conditional approval.
Okay.
Yeah.
trying to figure out the question.
So would you like the committee to postpone and you come back with a conditional approval? Or would you prefer a preliminary objection to come back with a changed text?
Why don't we do which would get us a quicker turnaround time? Because these are pretty, relatively straightforward edits that we can make.
Probably the conditional approval would be quicker.
Okay.
You wouldn't have to come back
Okay.
in that to us.
No, yes, you'd have to come back to, they haven't filed a conditional approval.
Oh.
So you'd have to postpone and they would file a conditional approval for the November meeting, October meeting, sorry, October
Okay.
meeting.
Okay.
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 So does the committee want to postpone to ask for a conditional
Madam Chair,
approval?
I move to postpone the rule and to provide the department more time to submit a conditional approval.
Second.
All right, thank you, Representative Hacken Phillips. And our deadline is October 28th, so it looks like we wouldn't even need a waiver.
That's good.
Thank you very
Great.
much.
Thank you.
Oh, excuse me. The motion is to postpone this. Those in favor?
Aye.
Opposed? All right, thank you. Good.
Thank you.
All right. All right, the Installation Standards Board.
Okay, this is 2024-85 installation and manufactured housing standards. The rules are expired. They expired in May of 2023. And the other issue is there's a citation that normally we would do as an edit, but it's the rule says 305A and I think it's supposed to be 205D. So it's enough of a change that it's a clarity issue.
Good morning, Tina Kelly, Rules Coordinator, Office of Professional Licensure and Certification. We can make that change as requested. And with regards to the expiration of these rules, the first part is that normally the towns, if they have staff, towns and cities, if they have staff, they do these inspections. The OPLC does not. But however, if a town or city does not have somebody to do the inspections, they will request that the OPLC do them using the board's rules. And we've only had one request in the past year, which was done, and there were no nothing found. There were no, and I don't want to use the word violations, but there were no
Citable violation.
citable violations found. And to that extent, any of the inspections would be done based off of the law. And it's very explicit in 205-D:3 and 205-D:5 what the inspection should include, when it should happen, and how it should happen.
You do mean 502, not 205?
205, I mean.
What does 205 have to do with these rules? These are 500 or formerly 500, currently 600.
I mean the RSA 205-D.
Oh, the RSA.
I'm sorry, RSA.
Excuse me. Thank you. No wonder I'm confused. I'm not used to such short numbers. All right. So, but the fee for inspections expired in 2013.
And I don't believe OPLC has charged it until they got their rules in place.
Has that been replaced?
And where is the fee citation?
Well, I'm just looking at your summary on the the last bullet is that former rule 50205, which expired 5/15/13, described the fees, and it's not included in this set of rules. So where are the fees?
Okay, they will be in any citations to fees within the board's rules, as I'm working on these rules because theirs are expired, will point to OPLC's rules, PLC 1000 something.
Okay, so that they are not included here
And those PLC rules were effective August 1st of last year.
of this year.
Last year.
Last year, okay. Did they include the manufactured housing inspections? I mean, because as I recall it, those fees were, we've been adding to them.
If I might help, Madam Chair, I think this has to do with that huge House Bill 655. And I think the manufacturing portion of that, the amendment to that, was dealt with last year. So I guess the question would have been if the rules for the fees had expired in 2013 and OPLC wasn't given the authority for the fees until, let's say, even last year, what happened between 2013 and 2023?
That I do not know. I checked on whether or not they had enforced the rules, how they enforced them. I did not look into what the fees were because they weren't in the year specifically.
The fees are in PLC 1001.17 for inspections.
Okay, thank you.
You're
So
welcome.
we're covered for the most recent year.
Mhm.
For the decade before that, we're wondering what the board did.
That I do not know. I can find out.
Thank you.
Please
Just
let
for
us know when you
curiosity,
find
we
out.
would very much like to know because this is a recurrent concern.
I will get that information and get it to you.
Okay. So these are the complete rules other than the fees for installation standards. Is that correct? These are the correct and complete rules for inspecting manufactured housing installations, and there's no other part that needs to be included. But
Not with this set, but they have other rules that will be coming through that have expired.
okay, so you have a whole bunch of expired rules as well as the fees, all right?
That's correct, and I'm working on all those to get them through as fast as possible.
Thank you. Anyone else? Does someone have a motion?
I'm just trying to figure out what the appropriate motion would be.
It would be a motion for oral conditional approval.
I'm sorry, can you repeat
It
that?
would be a motion for an oral conditional approval request.
Okay, so moved. I'll move a motion for oral conditional request.
Second.
Second by Representative Schmidt. Okay, so if I understand correctly, the Housing Insulation Board was moved to OPLC quite recently.
Correct.
Okay, so it's, all right, thank you. Any further comments, questions? Those in favor?
Aye.
Opposed? All right, good luck.
Thank you.
And we would like to know what happened with the fees before last year.
Yes.
All right. DES, alteration of terrain.
These rules were interim rules and they expired in 2008.
2008?
Yes.
I'm shocked. Any other comments?
The only other comment was a clarity comment on page 4. The department is using, so major potential harm means a substantial likelihood of causing harm to human health or environment or the environment. And it also uses moderate likelihood and small likelihood. And there was some discussion about how clear that is. It's a little subjective, but it's also, they're trying to create a scale of how they would meter out fines. And there's a table at the bottom that kind of shows what those would be if you had a moderate deviation with potential harm. So there is a clarity issue there, but
okay.
So I am Courtney Lockwood. I'm one of the staff attorneys for the Department of Environmental Services.
And Rainey Pelletier, I'm the Water Division Director at DES.
So we've been before you before about this issue with these fine rules that expired in 2008. And we're in the process of adopting rules specific to each program that requires a schedule of fines. And so this is the alteration of terrain rules that are before you so that we can try to fix this issue. We have not been charging fines absolutely in any program that doesn't have a schedule of fines since early 2022. For the alteration of terrain program, I don't have specific numbers. It's rare for us to go for fines in this particular program. Our preference is for compliance and restoration in all of our programs anyways, but alteration of terrain in particular. If we find out someone didn't get a permit, we try to get them to go through the process to get an after the fact permit and restore any areas that might have been damaged as a result of not having the permit in our review.
So these are fines primarily for not having a permit?
It's not just for having a permit. You could also have a permit that has conditions and you violated the conditions or didn't follow the permit. Those are less common for us, but that does happen.
Okay.
There's also some technical rules in here that were meant to address some objections that the Home Builders Association raised last fall. So this isn't just the fine rules, it's also to address those concerns that you all heard last fall.
Thank you. Representative Groda.
Just for a question for the JLCAR, I do believe that we had something something before us already by the Home Builders Association for terrain. Did we not?
So that was last fall. We had adopted new rules in September. And then the Home Builders Association sent you all a letter, I believe in October or November, I don't remember the exact dates, raising some objections. And the instructions from this committee was for all of us to meet and try to sort it out. And we did that. And this is the result of that. The fine rules had nothing to do with the Home Builders Association. We just already knew we needed to do those.
So the previous rules were the technical rules on how to apply and what the criteria were, correct? And this is about mostly the fines?
This is mostly about fines. There are 2 rules in there that were amended in order to address the Home Builders Association's concerns.
Okay, thank
We
you.
added some flexibility, basically.
I'm sorry?
We added some flexibility to our rules to address their
Always a
concerns.
good idea. Any other questions? Representative Leon?
Thank you, Madam Chair. My question was just around the minor, moderate, and major potential for harm. And I just wasn't sure if there was any way, because it's hard to prescribe that going forward, to sort of review it after the fact to make sure that it's been consistent and see if there's any rule changes needed for clarity. Is there a process for that?
For reviewing how they're interpreting it?
Yes.
These rules are new. It's the same language that was adopted in other fine rules. We can't really seem to figure out a way to word it differently. Keep in mind, these are proposed fines. So the criteria is just to help us determine proposed fines, but then the person has the right to a hearing. And so the decision is actually made at the hearing.
Oh.
This is just guidance that we use to initiate the proposed fine.
And this is the exact verbatim language as other proposals that have been approved in the past. And like I said, we talked about it a lot, and I can't figure out how else to word it either.
So these numbers, you say, well, there's moderate. We don't really know which. All right, we'll fine you $1,250, and that's the start of the negotiation.
Yes.
Okay.
Either negotiation or it goes to a hearing.
Well, at the hearing, I'm sure there are negotiations, even if the hearings examiner makes the decision.
Yes.
I have a question.
Representative Broda?
So the permit is issued by your department?
Yes.
Follow up?
Follow up.
And so if someone, let's say, Mr. Smith is an inspector and he fines so-and-so $1,250, how is it possible that is it the same person that issues the fines that has the criteria for this? How are these fines issued? And is it because two people could have two different standards, right? They could have two definitions of what moderate is.
All administrative fine actions go through our legal unit. So it's centralized of who makes that decision in our legal unit. And we just make the decision of what is proposed and bring that action. And then it's up to the hearing officer and ultimately our commissioner that makes the final decision. So the hearing officer makes a recommendation based on the hearing and the commissioner makes the final decision.
Last follow-up.
Follow-up.
So in the rules, you define the significantly altered characteristics of the terrain, right? Because that's what. So is it possible that within that definition, you can, I'm going to assume that it's basically how much dirt you move. And,
That's the basics of it, yes.
Right.
How much earth you have disturbed, yes.
Exactly. Disturbed you and in relationship to protected land, whether it be wetland, shoreline, it's in relationship to that, correct?
Not necessarily. This is for regulation of stormwater. So
Okay.
So
Okay.
if you are close to, say, protected shoreland, there you can disturb less land and still need a permit.
Correct.
The general criteria is 100,000 square feet, but there are situations where it could be less and you would still need a permit.
So has the department looked at, in relationship to this moderate, maximum, minimum thing, the amount of dirt moved? I mean, is that a criteria that you could use? No.
No.
Okay.
It's where the dirt was moved from and to, as much as how much, I imagine.
Thank you.
All right, any other questions, comments? All right, does somebody have a motion? I'd like to comment that I'm extremely concerned that your cross-program rules expired better than 15 years ago, and you're just now getting around to setting the fines. That seems very unprofessional.
And we assure you that that's what we're trying to fix. And I'm also assuring you, our commissioner for several years now has said, if you don't have fine rules, you are not proposing fines. So every program is stalled until we have fines. But we only have so many staff to propose rules, so we're trying to get through them all.
All right,
I have
thank you,
a
Representative
question.
Broda.
So sorry, I have another question. So you had a public hearing for these proposed rules, and what was the comment to those rules and to the potential fines?
There's, starting on page 6, there's a summary of comments and response there.
Thank you.
And it says that no member of the public provided comments.
We had a few people show up but did not comment, and then we didn't receive any written public comments.
Okay. I'm amazed that you managed to get an alteration of terrain, no matter how narrow, through without any public comment. So I've got to congratulate you on that part.
Thank you. We were surprised too.
Right. Anyone else? Comments, questions, motion?
We're all going like, we don't want to do it either, you know.
Well,
Is this similar to the previous proposal where we have questions that we can give them an oral conditional?
no, because we don't know specifically what we want them to change them to. For conditional approval, we have to have a specific section saying, change this. In this case, it's only the concern about the expired rules appears to be the only noticeable comment. So, in that case, I will move to approve with issues.
And now, second.
Second by Representative Lynn.
We're all going.
Anyone else? Comments, questions?
Hell of a way to run a railroad, but
Those in favor?
I.
Those opposed? Thank you, and I hope your other rules are moving right along.
Thank you.
All right, speaking of which, the Cyanobacteria Mitigation Fund.
So these rules are also expired, but let me find the year.
More recently, I hope.
More recently. Sorry, I lost my place. Here we go. Expired
July
of 2024. So much more recently.
All right, so that-
And the only note I have on here is that there is it's the Cyanobacteria Mitigation Fund, and so there are contracts that are made with the people that are getting the funds and the grants. That's usually not something that we can evaluate from a rules perspective, but the kind of meat, the guts of the contract are in the rule text, and they also go through governor and council for approval. So that's kind of how that function works. It's just it's not all written out in the rule because it's a contract. So
okay. Any comments?
Again, Courtney Lockwood, attorney for DES.
Amy Smagula, I'm a freshwater biologist at DES.
I don't have any comments on the loan piece of this. We have another set of rules with this exact same language. The drinking water state revolving fund rules, which is where we pulled the language from that was approved previously, I believe in 2021. In terms of expiration, this was a new statute, and so we had to quickly adopt interim rules. That is what expired in July. And so this isn't about taking money, this is about giving out money. So I think we've only received one application since the time they've expired. And we are without rules, we have 60 days to make a decision, and we're still within our 60 days to make a decision. So we decided to hold off on making a decision since we did not have rules. But if these are approved today, they will be adopted in time so that we can still meet the 60-day deadline under 541A to make a decision, and we will have the criteria for approval to be able to do that.
How convenient. All right, anyone else, comments, questions? Okay, Senator Chanley moves to approve.
Second.
Second by Representative Grassi. Any comments, questions? Those in favor?
Aye.
Opposed? Okay, thank you very much.
Brucey Day.
Well, it was for grants, and if they're holding off on the one request, I think that's about all we can ask them to do. Okay, HHS.
So this is proposal 2024-108, protected income level. The only comment I had on this was a note to the committee because the notice states that the rule is implementing for the first time Chapter 39 laws of 2020. I did look into the legislative history of this statute, and even though it took effect on June 30th, 2021, it was then temporarily suspended under Chapter 91 laws of 2021, which took effect July 1st, 2021, and then was reinstated effective January 1st, 2023. So even though the law first came into effect on 2020, it really hasn't been fully in effect since January 1st, 2023, but that still is over a year since the statute went into effect. So my note was just questioning why it took so long to get this rule into place after that went into effect.
Yes, thank you. We'd like to know that. I can understand it being suspended by HB2, but that's been a while.
Sure. Good morning, Nicole Valenzola, Administrative Rules Coordinator for Department of Health and Human Services. The chapter law did go into effect 1/1/23, which did issue then authority to DHHS to be able to begin to implement this and do internal processes and changes in the state plan approval, which did immediately happen. And this did benefit recipients immediately, and we started doing that. And then it did just take us longer to get the rule into place. We got held up a little bit with some financial conversations internally and with LBA. And here we are.
So do I understand you correctly to say that you started implementing the law in 2023 and are just now getting around to having the rules?
Yes, so we began implementing it through, because we did have statutory authority to do that, and we had to update the state plan, and we did do that. Internal processes were done, documents, policy changes, everything went out, began immediately helping those individuals who receive this PIL, the protective income limit, increase that. Began working on the rule, hit some bumps, things got held up, and we've just continued to work it, and we're here now to have it adopted.
So it sounds like the rule is an afterthought. Is that correct? Or is it just the last step in a very long
It's a last step of a long process that also got tripped up internally with conversations and with LBA.
Rob Berry, General Counsel to the Division of Medicaid at DHHS. To be clear, the chapter law itself is very prescriptive as to how we were to implement this. So the rule is really just a recitation of the results of the chapter law, but the chapter law really controlled here. Traditionally, the legislature has not been so prescriptive as to how to implement the protective income limit, which is why we've needed rules in the past, and we'll need rules going forward. But this was just kind of a unique piece of legislation. So we were relying on that authority. And we did feel that it was more important to get the state plan amendment in place, which was our federal authority to implement, as well as inform the field and develop processes so this could be applied. So the long and the short of it is no one was harmed by our deficiency here with getting this rule in place. And we do recognize that we were deficient with that, and we should have done it a lot sooner than that. But I did want to clarify that what the process was.
All right, thank you.
Madam Chair?
Other questions? Yes.
Just to clarify, the chapter law, though it does give the commissioner of the department the authority to amend the income eligibility requirement for in and out medical assistance, it gives the commissioner two options. It says that it can the commissioner can either amend less than or equal to 133 1/3% of the section 1931 income limit, or using methodology as described in section 1902 R2 of the Federal Social Security Act. So there was some choice to be made by the department that had to be done via rule.
We elected the first option, just for clarity.
Okay, thank you. Questions, comments, concerns?
Move to approve.
Second. Okay, moved by Representative Schmidt, second by Representative Lynn. Discussion? Those in favor?
Aye.
Opposed?
Thank you.
Okay, passenger tramway safety rules.
Okay, so this is proposal 2024-145, various passenger tramway safety rules. There were a couple of unclear comments for this proposal. The agency did not file a conditional approval request to address those issues. The first appears on page 1 of the rule text. It's an edit unclear comment. Due to the citation of the incorporated material being different than other sections where it's cited, as well as in Appendix B. In that particular spot, it is cited as ANSIB 77.1-2022, but everywhere else it's ANSIB.77-2022. So it's unclear because it either is an editorial error, which can be easily fixed, or this is a different part of the document, in which case that needs to be cited specifically in Appendix 2. The second comment is on the bottom of
Excuse me,
page.
that sounds like something we'd like to get out of the way.
Sure.
Hi, good morning. My name is Briggs Lockwood. I am the chief for the Department of Safety of the Tramway and Amusement Ride Bureau. So, oh, yeah, go ahead.
Good morning. My name is Michael Dejoux. I'm one of the staff attorneys with the Department of Safety.
So, yeah, I think it is just an editorial. We're talking about the same document in all of the places, and it looks like it was an oversight, and in one place it was listed differently.
All right, thank you.
So
the statute has been updated. Or, I mean, it's not the statute, the standard. The ANSI standard has been updated.
This is the latest version of the ANSI standard, which we wish to adopt, 2022 version.
Thank you. Okay. Anyone else?
I'm sorry if I may, it supersedes the 2017 version.
Okay, so that's 2022.
So that issue could easily be fixed with an oral conditional approval, but there's still two other substantive comments. But I also, just on that issue of the updated incorporated document, I also just want to make the committee aware that the department did submit a summary of the changes, which was included in the packet, because it looks like there were some pretty, quite a number of changes. And it looks like that summary comes directly from the organization who updated the document.
That seems highly appropriate.
The second substantive comment is on the bottom of page 2. It's an unclear edit comment. The notice for this proposal stated that a definition was added to this particular section of the rule. However, it's unclear what term was being defined, as it was not laid out in compliance with the manual and it was not specified. So in that particular section, it's either new installation or modification. I couldn't determine which term was meant to be defined, or if both were meant to be defined. And then additionally, the setup of that particular rule is not in compliance with the manual, as they have language right after the section title, but it's not introductory language for the subsequent paragraphs. It simply seems to be its own paragraph. So that entire section needs to be reconstructed.
Well, that sounds like an editorial comment. But so you have the modification is the new definition, and you're basically redefining it as a new installation?
I do understand the confusion here. Really, the intent here was to describe what would occur involving a new installation if there's movement, if there's an alteration in length or movement of the passenger tramway, and that the end result would consider it a new installation. It wasn't, the intent was not to define new installation per se.
Okay, so is there a new definition in this section?
I would say no.
Oh, okay.
So that issue, if it was just a discrepancy between the notice and the rule text, is fine. So it'll just, the remaining issue would be to restructure that section to be in compliance with the manual by having appropriate introductory language for those subparagraphs, which might take a little more work than a oral conditional approval that we could do right here. And then additionally, there's one final comment on the bottom of page 3. It's an unclear comment. The rule requires that plans to replace a prime mover motor or plans to change or replace a control system shall be submitted to the department along with the application and specifications. However, the rule then goes on to state that the department shall allow the completion of the modification testing of the submittals if they meet the standards, but then the board shall review the application at its next scheduled board meeting and should determine if the modifications conform with the standards. So it's unclear who exactly is making the decision of whether they meet the standards, and also if it is ultimately the board who makes that determination, why the department is allowed to give an initial approval prior to the board's decision.
I have an answer for that. In this day and age where the electrical systems that control the motive parts of the ski lifts and the control systems that monitor these machines that are a mile long, these systems are becoming so sophisticated, and as I'm sure we all can understand, they become obsolete after not very long. A ski resort may be faced with having to replace some of these components, which by definition, it's a modification of the tramway if it's not exactly the same part number. And once these components become 5 or 6 years old, you cannot buy the same part number. They're forced into this modification. The trouble is we would have to convene the tramway board in order to act on this under the current situation. So what the board agreed to do in order to expedite this for the businesses that are trying to operate this equipment is to submit the designs to the department and have us review them, and that way they can move forward with the installation and testing and operation, and then the board would then review it. So the board effectively is agreeing to defer that to us for the temporary period of time until their next meeting.
So what happens if the board decides that the application is not correct?
Well, it says they will identify the area or areas of nonconformance and stipulate a reasonable time frame for conformance.
Okay, so the owner of the lift is on the hook for making sure the board has approved their design modifications.
That is correct.
Thank you. I thought that was the case. Any other questions?
No.
Comments?
You gotta do it. You gotta do it kind of as built. Gotta build it to the situation, right?
Okay. All right.
And you test it, see that it works.
That is correct. Yeah, we would require a qualified engineer to review and stamp the project, and that engineer then is responsible for any testing. Testing would be completed. And so it's really the same drill that would happen with the board's approval. They're just deferring everything to us so that it can be done.
Okay, well, there's also that clarity issue that needs a rewrite.
Could we move to give them a conditional approval and come back in October?
So we could postpone and allow the department to submit a conditional approval. Also, looking at the rule, was the intent to have that language right after the section title just as its own paragraph, and each subsequent paragraph is its own paragraph? This is section pass 305.03, starting at the bottom of page 2.
I think we'll still have a point.
Because if that's the case, then we could do an oral conditional approval to just move that, make that paragraph A, and re-letter the remaining paragraphs if they're all standalone paragraphs, and then additionally fix that citation.
Okay.
We're not opposed to make that change per what
Fine.
the
I
committee would
think
like us
that
to do.
making it a new paragraph is simple enough that the oral request would be valid. Okay, so we have a motion.
Second.
And just comments, questions?
Wait a minute. Are we seconding my motion? 'Cause my motion was to postpone, was not an oral
Oh.
conditional approval. Should I change my motion? Would
If
that
you'd
be?
like to.
Sure. I'll change it to an oral conditional approval. I just want to make sure that we have the same motion. I'll withdraw my first one and I'll change it to this.
Second.
All right. Fine. Motion by Representative Grota to conditionally approve this with the editorial comments indicated, and second by Representative Schmidt. Representative Lynn, excuse me. All right. Any comments, questions, concerns? Those in favor?
Aye.
Opposed? Thank you very much.
Thank you. Thank you.
All right, Representative Fellows, you're sitting in for Representative Schmidt since he has another meeting to go to.
Yes, I do.
All right, under the Department of Natural and Cultural Resources, we have three administrative rules, three emergency rules.
Madam Chair,
Yes,
I think there is one item before that.
not on the agenda I have. It
I'm
goes,
sorry. I
it
was
goes
looking
straight
at the,
from the Passenger Tramway Safety Board to
Okay.
other.
thank you. We have representatives from the department here. My concern with all three of these proposals, and I'm going to discuss all of them together, is whether or not there's actually imminent peril to public health or safety or substantial fiscal harm to the state or its citizens. The attachments to each of the emergency rules, which go into the details of why, don't seem to state that there's an imminent peril or substantial fiscal harm. So there's a question there of whether it falls within the definition of an emergency rule. Also, I would note that the department has been enforcing the rules created by DRED. Those were done in March of 2014. Since then, as you know, DRED has been split into two. One of the departments is Natural and Cultural Resources. These rules, the rules that they were enforcing from DRED, expired on March 1st of 24. So the department had 7 years to go through regular rulemaking or interim rulemaking to put these into place. There's also been enough time since March 1st to adopt either regular rules or interim rules. So again, the need for these at this moment outside of regular rulemaking is questionable.
Yes, I would agree that the question is why is this an emergency when you've had 6 months since March to adopt the DRED rules as interim rules, which would be a very simple thing to do.
Good morning. My name is Taurine Tangaloe. I am with the Division of Parks and Recreation as a program specialist, and I assist the division and the department with their rules. And the division is in the process of updating its rules. We've not been able to finalize some decisions on the rules with the commissioner and director. They're still reviewing some of these rules. Both commissioner and director especially are fairly new to the department and division. So they're still contemplating some of the rule changes that we were wanting to make. We submitted administrative rules and we are not particularly practiced on rulemaking, and we're not aware that interim rule may have been a better process. to keep these rules in play while we finish regular rulemaking.
Yes, because that would in fact be the appropriate. You're specifically allowed to adopt interim rules to shorten the time you have no rules effective. Director Morrow?
I would note that there are two other issues related to this. One is that under the rules that have expired, there's fee-making authority. And while the regular fees for state parks are exempt from 541A, however, administrative fines are not. Also, there's a separate statute regarding Hampton Beach for which the department is responsible for the parking, which includes fees for parking or parking meters and fines for failure to comply. Additionally, well, I also want to inform the committee that the department a few years ago adopted natural heritage inventory program rules, but no other rules have come forward. The department has no Chapter 100 organizational rules or Chapter 200 practice and procedure rules.
All right, well, that's a challenge. The question I have is, have you been collecting any fines since March? Which I imagine this is your busy season.
Yes, we have. With regards to the parking fees to park along the seacoast, as well as the fines for violations of parking, we have been enforcing that.
You realize that that's illegal.
We do now. Okay.
I would note that I believe the fines, and I'll double check with Kim, but I think the $250 fine is set by statute.
Yeah, the statute at 12A2C caps the fines at $250, but does require the agency to develop a schedule of fines and procedures for those fines.
Right. Well, if it's set as a maximum, I mean, I understand most agencies interpret that as the minimum, but realistically, you could be giving out $50. You could choose to give out $50 fines, and that needs to be enrolled. All right. Anyone else? Comments?
I have a
Director
question.
Morrow? Yeah, Representative
So are we saying that there is no fee schedule on these rules?
There is a fee schedule in these rules.
In these rules, okay.
But their
Yes.
previous authority expired in March.
Correct, I understand.
So if you got a parking ticket at Hampton Beach this summer, it was illegal.
Well, if you paid for parking at Hampton Beach.
Correct.
If I may as well clarify something. So the department also has statute that allows it to set its fees and present them to the Joint Legislative Fiscal Committee. So such as our entrance fees, admission fees, it includes our parking fees and fines that was submitted to Fiscal Committee and approved. So those are some of the fines and fees that we are working off of.
Yeah,
Director Morrow, is it correct that the fees and fines would have to be approved both by fiscal and by JLCAR? That appears to be
The
excessive.
fees for state parks does have an exemption from 541A, as I mentioned. However, the fines for any state park are through rules, although the statute caps it. And any fees or fines for Hampton Beach parking would need to go through rules. Unless there is another statute that I missed, which is always possible.
Don't think there were any changes. So what are what are our options in this?
Because these are emergency rules, the committee cannot object. If the committee feels that there is no legitimate emergency, then it can petition the department to repeal their emergency rules. And the committee may wish to make recommendations about adopting rules, these rules for regular rulemaking, perhaps the 100 and 200s.
Does someone wish to make a motion, recommendation, request? That's about all we can do is ask. Representative Rhoda?
Does your department have a rules coordinator?
She just retired like 2 weeks ago. And so I've been assisting her through the years on Division of Parks and Recreation rules, to my limited knowledge, but we did have someone.
I have a question.
Yes.
So if we don't, what are the, if we take your position that, or we support your position that these are, the emergency rules are not warranted, what's the, I mean, what would be the other option? That we keep things, you know.
The department could undertake interim rulemaking immediately to put the old rules back into place. Even though those were dread rules, I think they could still use the interim rule process to put them in as rules under this department.
And that would start with a motion from us?
The committee can make that motion, but the department could do that at any time.
All we can do is request at this point.
Well, we can strongly request,
Yes, yes.
right?
All right.
And I would second a strong request.
All right.
So I make a strong request from the committee that the department undertake interim rulemaking immediately. And that, when would they be coming back here?
Actually, if the emergency rules stay in effect, the committee doesn't petition them, or the committee petitions them and they deny the petition, then those rules are in effect for 6 months, so they could undertake regular rulemaking.
Which I understand that you are in the middle of regular rulemaking on these issues.
That is correct. Yes, we are.
Okay. And we would, I think that perhaps we should say that they should continue the regular rulemaking on these, and they should adopt as interim rules all the procedural rules from DRED that they are undoubtedly following, but don't have in effect. Would that make
Yes, yes. So moved.
All right. Second by Representative Grassi. Yeah, you should adopt as interim rules all the rest of the DRED rules that you should have for your operations, as well as continuing the regular rulemaking for these rules. Thank you. Representative Leon.
Thank you, Madam Chair. Mr. Morrell, in order for, I guess I'm trying to understand the process regarding the emergency rules and us not seeing them as reasonable. Did you say that we would petition to say that the emergency rules are not valid? What would be that process to then move this to the interim rules and the regular rulemaking?
If the committee feels that there is not a legitimate emergency, its only option is to petition the agency to repeal those rules. The agency has to respond within 30 days by letter.
And I think it would probably make sense to make that motion, so I'd make that motion.
I'll second it.
Okay.
Can I just
Representative Lynn.
said I understand the sentiment behind the motion and the response, but I just kind of, I mean, it seems like, and it's not only with this agency, but what we've heard today, that there is sort of generally a problem with having rules kept up on time. And my only concern here is that if we file this thing, if we make this motion that is suggested, what that's going to mean is that the department is now going to have to devote time to responding to that, and presumably, which will take away from their time from actually working on the rules. And so I wonder if, are we sort of biting off our head to spite our hand? That's my only concern about it.
Madam Chair?
Senator?
I see what you're saying. We want them to focus, but they actually don't have to respond. They could just accept that and just move forward on the interim rules. I understand sort of the dilemma here. And also we have a very clear sort of legislative prescription about when emergency rules are appropriate. So I think it's more appropriate for them to move into interim rulemaking.
Yes. And I'm kind of amazed that in 7 years, the department has not moved on any rulemaking except one narrow program. And so that's of concern.
I just have a question.
Yes.
Clarifying. I don't believe there are two motions on the table right now, but perhaps there are, or can I just be?
Representative Broda made a motion and we are discussing it.
Okay, but I thought Representative Leon also made a motion.
She said
but-
she wanted to make a motion.
Okay,
Yes.
got it. Thank you.
Thank you. And
So if you could, Representative Broda, if you could restate the motion that we're discussing or trying to.
All right, so I'm gonna try to remember. The motion is that that we strongly recommend we strongly request that the department continue its rulemaking process, but start the interim rulemaking process for those rules that are not in the making process, and that was there a third part of this? Was that it?
Well, the third part is what kind of fines did they collect over
Oh,
the
yes,
summer?
right. And what kind of, to report to us what kind of fines and unauthorized income was collected by the department.
Got it.
Director Morrow?
I'm somewhat concerned about asking them to go through interim rulemaking for other rules such as the 100 and 200 rules. The reason being, an interim rule like that, to bring back expired rules, the rules have to be the exact same language. Organizational rules describe the organization, describe the agency. A description of dread would not be the same as this department. So I'm not, as I say, I'm not sure that it would be appropriate. I can go and look at the 100 rules and the 200 rules and talk with the agency about it and report back to the committee.
And just to clarify, they're not currently in formal rulemaking. I looked up on our database and there is no current rulemaking taking place. So if they're doing any, that might be internally to the agency.
Okay. Do you wish to amend your?
I'll amend my motion. We strongly recommend that the department takes on interim rulemaking so that you have the authority that you need and that you include in that the specific authority that you have in collecting fines and issuing fees, which are in your emergency rules, which we're not going to obviously approve.
We don't have to approve.
Right.
Okay. Is
Is that better?
everybody clear?
Mm-hmm.
Madam Chair.
Yes.
I just think it'd be important for JLCAR to ask the department to take an internal assessment of its rulemaking and rules on hand to determine if they need to initiate other rules as well. It sounds like this one flipped through the slept through the cracks. So it might be worth a second look to make sure that there are not other concerns.
I can add that to my motion.
That's a very good point.
I'll second the motion.
Second, okay. Any further comments, questions, Director Morrow?
I'm still concerned about using the interim process if it's going to be used.
The motion doesn't mention interim. It
Okay.
just says that they continue their rulemaking
Okay.
and that they assess their rules or the previous department's rules to see what rules they need,
Understood.
because this is not the proper purpose for emergency rules. Is that?
And for
Comments?
moving forward, please don't hesitate to reach out to us for help in the process.
I appreciate that. We will do that. Thank you.
All right, any other comments? Amendments? Yes, for Director Morrow.
I would ask if the gentleman could identify himself for the record.
Good morning, Colin Capel, Chief of Staff, Division of Parks and Recreation.
All right. Those in favor?
Aye.
Opposed? All right, good luck. Okay. Thank you very much.
Then,
All right.
Madam Chair,
Yes,
did we want to look at petitioning the emergency rules because without that petition, they would go into effect, or is it, have
They
we,
have
have we
gone
already
into-
made that
they
statement?
have gone into effect.
Okay, so we've already made the statement that we're very displeased that they did not take the right path, but we won't further burden the department.
Right.
Okay, thank you.
When we get the strongly worded letter from the staff, we will distribute it to the committee as well as the agency. All right. The last discussion item is the letter from the DRA about the equalization manual. I read the letter and it sounds like the agency was groveling sufficiently. They basically said that the people that identified the equalization manual as guidance and not a rule were wrong, and that they will be corrected. The only concern I have left is that the equalization manual is adopted as a rule, but some parts of it are in fact guidance or suggestions rather than actual rules. So, but that's something that the DRA has to deal with. We've approved the equalization manual as a document. And did anyone else read it or have issues with it? Apparently not. Director Morrell?
I just had one final note. For the next two committee meetings, October and November, there will be two directors of administrative rules here. As some of you know, I'm retiring at the end of November, and we have hired a new director, but I'm going to stay on for 6 weeks to help train him. It is Douglas Osterhout, legal counsel for the OPLC.
Okay. We'll break him in gently. All right. All right, so I think we are, by consensus, we're going to cancel the continued meeting and adjourn. Anything else? All right.
All right.
Thank you all.
Thank you.